My lords and my lady, I'd like to try and pick up the sort of structure of my submissions as I'd intended it to be before I decide to digress onto whether the rules are a mirror or a codification of Article 8 or something slightly more nuanced. What I'm going to start by doing, we've covered it to an extent this morning, but I hoped it might be helpful to have a brief overview of how, under domestic law, we approach claims to remaining in the UK on Article 8 private life grounds. And I'm effectively just developing the submissions that you'll find at paragraphs 10 to 13 of our case, MS 98 to 100. The first point, and perhaps it's so obvious that it goes without saying, is that domestic law provides for people to be able to come for temporary stays here on a wide number of bases, which include study, work, as entrepreneurs or investors, for a number of other purposes. And such a person will be entitled to remain for so long as she or he continues to meet the requirements of the relevant rules. Their leave will be time limited, but it may also be subject to other conditions, such as remaining in employment, or as Mr. Southey alluded to this morning, making sufficient academic progression and securing and keeping a place on a particular course. If a person maintains their stay here lawfully and complies with the rules and continues to obtain leave, the immigration rules make specific provision for indefinite leave to remain, to be granted on the grounds of long residence after 10 years. And we looked at that briefly this morning.
That's lawful residence, is it?
Lawful residence, yes.
Very well.
I'm not going to turn back to it because we looked at it this morning, but it's at volume 2 of the authorities, tab 17, MS 661, and it's paragraph 276B. Thirdly, the immigration rules also contain express provision for leave to remain on grounds of private life that's been established here. That's also in Authorities Volume 2 at tab 17, and that might be worth turning up briefly. It's MS 662, and it's paragraph 276 ADE. The headings at the very bottom of MS 661, requirements to be met by an applicant for leave to remain on the grounds of private life. And you'll see that there are a number of provisions which include that the person doesn't fall for refusal under any of the grounds in section SLTR. We won't turn those up, but those are effectively the suitability requirements, so there'll be things like good character. Valid application's been made, then has lived continuously in the UK for at least 20 years, discounting any period of imprisonment. That's not lawful residence, that's any residence. Or...
So that's the subject of her recent grant, is it?
Subject of?
The subject of the appellant's recent grant?
Yes, it is. That's right, my lord.
Very well.
But they include provision for young people under the age of 18 who've lived in the UK continuously for at least 7 years, if it wouldn't be reasonable to expect the applicant to leave the UK, or somebody aged between 18 and 25 who spent at least half their life living continuously in the UK, or somebody aged 18 years or above who's lived continuously in the UK for less than 20 years, but who face very significant obstacles to integrating to the country to which they'd be required to go if they had to leave the UK. So it's quite a detailed set of provisions. Part 5A only comes into play if somebody doesn't qualify under the 10 years lawful residence, doesn't qualify under the Article 8 provisions in the rules, and as did this appellant, applies for leave to remain on Article 8 grounds, asking for that outside the rules, and then that falls to be determined firstly by the Secretary of State, but then by the first-tier tribunal. And this structure represents the Secretary of State's policy, as approved by Parliament, as to how individual private life rights should be balanced against the public interest in the maintenance of immigration control.
That's 276ADE1. You say that's the policy.
Yes.
This came in 2012, I think, didn't it?
Yes.
For our Act.
Yeah. Because Article 8, as you know, didn't used to be catered for within the immigration rules at all.
And we said, I think, that this doesn't bind the tribunal as such, but they're expected to have regard to it.
Precisely, yes.
What sort of regard? I mean, if there's an application outside the rules, as in this case, everybody says, the law says, apparently, have regard to the fact that she hasn't got in under this. But how does one factor that in any logical or sensible way, Miss Giovanetti?
Well, under the statutory scheme, it's the first of the criteria that Parliament's set out. If we go back to Volume 1, tab 10, where we've got Part 5A. So if we look at 117B, 1, the first specified factor to which the court tribunal should have regard is that the maintenance of effective immigration controls is in the public interest. And that reflects the approach of the Strasbourg Court, in fact, because staying with this bundle, if we turn to Jeunesse, I think we picked it up this morning at 101, but we missed out paragraph 100, which is the beginning of the court's assessment. It's MS 547 at tab 9. So it starts off by saying that the present case is concerned with a refusal to allow the applicant to reside on the basis of family life, hasn't been disputed, there's family life, and then picking it up at the end of line 4. As to the question of compliance with this provision, that's Article 8, the court reiterates that a state's entitled as a matter of well-established international law and subject to its treaty obligations to control the entry of aliens into its territory and their residence there. The Convention doesn't guarantee the right of a foreign national to enter or to reside in a particular country. And then importantly, the corollary of a state's right to control immigration is the duty of aliens such as the applicant to submit to immigration controls and procedures and leave the territory of the contracting state when so ordered if they're lawfully denied entry or residence. That's quite important because that's part of the context which gives rise to the distinction the Strasbourg Court's drawn between withdrawing the residence rights of a settled migrant and the position where somebody who's present precariously is asking to be granted further leave to remain. So I say that's how it factors in. It factors in domestically under the Act. It factors in Strasbourg as part of the whole context. So if as a matter of domestic law somebody is required to leave, there has to be something under Article 8 which outweighs that public interest. So if we can turn back then to that tab, to the language and structure of Part 5A, the first point, and it's something that I touched on this morning, and it's the suggestion that precarious effectively means unlawful. I'm not going to turn to it, but the Court of Appeal addressed that submission at paragraph 32 of the judgment. That's in the core volume at the appendix, page 14, it's MS 143, paragraph 32. And they made the obvious point that if precarious simply meant unlawful, 117B5 would be entirely OTOs, because 1174, if you leave out the relationship point, already says that little weight should be given to a private life established at a time when a person is in the UK unlawfully. So 117B5 must mean something different.
There are obviously some people who are here lawfully but without any leave at all.
temporary admission cases, my lord.
And I suppose asylum seekers.
Well, those will, asylum seekers will fall within the temporary admission cases. So, as you may recall, this court held, I can't remember the name of the case, although I was in it, that in some circumstances where somebody presents at a port, and it usually is they ask for asylum or Article 3 protection, they will be temporarily admitted to the UK while they're awaiting a decision. And for some purposes, they're not treated as having entered at all.
Yeah.
So,
Thank you. But are there other, what I was going to ask was, are there other categories of people who fall between the unlawful and those with temporary leave?
those with limited leave. The only
Limited leave.
one I can think of, and I can't remember precisely how it works, but is the position of somebody who is born in the United Kingdom, of parents who are here unlawfully, and there's a bit of learning about that, potentially that would, but then not any sort of significant category that would affect a large number of people.
Thank you.
So, if precarious doesn't mean unlawful, what does it mean? And we'd say that actually the right answer is that represented by the upper tribunal decisions from the very inception of the Act, from when they first considered it. And there are two in particular. They're important decisions, one of the Vice President and one of the President. And if we look at them in order of time, the first is the case of, they're both in Volume 1 in the core authorities. One is the case of AM Malawi, which you have at tab 2. MS page 290. The report starts at MS 291. And you see this is a decision of the Vice President and Deputy Upper Tribunal Judge Holmes. And you'll see from the head note that this was what you will see is not an unusual situation, as with this appellant, of somebody who arrives as a student and gets successive periods of leave and then wants to stay permanently afterwards. And the appellant in AM had brought his wife and child over, sought to remain on the basis of a risk of breach of his wife's rights under Article 3, then applied for asylum on his own behalf, and eventually the case came before the upper tribunal. And we'll come back to this when looking at the English language and financial independence requirements, but I wonder if we could just look at the section that deals with precariousness first of all. And we can pick it up at MS 300, paragraph 20. The upper tribunal didn't think that significant assistance could be gained from the case law, where the term precarious has been used both domestically and in Strasbourg to describe a variety of different situations, and sometimes to describe an individual without any lawful status. They then summarised the Strasbourg case law as it then stood, because this was pre-Jeunesse, by reference to the decision of the Court of Appeal in Nagre, which was, I think, the first domestic...
Lord Justice Sales again, isn't it?
It is,
Yeah.
yes. And I think it was the first domestic authority which really teased apart the distinction between the expulsion cases, as Strasbourg termed them, so the cases involving the deportation of settled migrants, very often people who had grown up in the host state, or even second-generation migrants who'd been born there, but then committed criminal offences. And on the other hand, the other line of cases that dealt with precariousness or non-settled migrants, people who were asking for a grant of leave rather than having their leave withdrawn. And so Nagre looked at that, and it's a much-cited decision now. So paragraphs 39 and 40 at MS 301 are a citation from Nagre, including at 40 the long line of cases identified there as the exemplars of the non-settled sort of cases and the different approach. Then there's reference to the decision of Mr. Justice Green in Ahmed. And at 23, the tribunal really pick up their own reasoning. They say, our starting point must therefore be that Parliament has now drawn a sharp distinction between any period of time during which a person's been in the UK unlawfully and any period of time during which that person's immigration status in the UK was merely precarious. So they effectively carry on at paragraph 23 to make the point I was just making, that these are two different concepts within the Act. At 24, they reject the submission that precariousness is to be assessed by reference to the length that somebody has been present. And at 25, they reject the suggestion that the answer is to be found in the person's subjective belief that they'd be granted leave at some point in the future. And then...
So that is a bit of a divergence from Strasbourg, isn't it?
Well, I think it's an understandable one because, as Mr. Southey pointed out this morning, if you look at it in the context of family life, there might well be other family members who were not aware of the fact that one of the parents has got precarious status, for example. But we're only looking at it in terms of private life. And so it's difficult to conceive of a situation where somebody who's granted leave as a student for 3 years, for example, doesn't know what their own immigration status is. So that's probably why Parliament hasn't formulated it in terms of awareness of precarious status. It makes sense when you're looking at, was family life established in the knowledge of that its continuation would be precarious? It's less significant when you're looking at private life.
Yes, thank you.
They then set out, and I'd ask the court, I'm not going to read it out loud now because I'd like to make sensible use of the time available, but I'd invite the court to read paragraphs 27 to 31 in total, and I'm just going to turn to 32 because that's the nub of it. To put the matter shortly, the upper tribunal said, it appears to us that a person's immigration status is precarious if their continued presence in the UK will be dependent upon their obtaining a further grant of leave. It's precisely because such a person has no indefinite right to be in the country that the relationships they form ought to be considered in the light of the potential need to leave the country should that grant of leave not be forthcoming. And en route, in the paragraphs I've skipped over, but that I do rely on, they make points such as the fact that the immigration rules can change from time to time, of course. And other unexpected eventualities can occur. A business might fall through, somebody might fail their exams and not have their college place maintained. So it's not... That all contributes to the precariousness of it.
This appeal, though important, is academic, because very recently the appellant was granted 30 months.
Yes.
Is her status then precarious?
Now?
Now.
Yes, it is.
Yes, we will. Yes.
Then that approach, on our primary case, yes it is, and I'll come back to that if I may, that approach was endorsed by the presidential panel of the upper tribunal in the case of Dealer.
Could you just help me on one thing? I noticed at paragraph 15 of this decision we've just been looking at that they referred to something called the Human Rights Memorandum that was published as an accompaniment to the Act. Presumably, was that a document which certified its compatibility with the Convention?
I expect it would have been that document. I mean, certainly that there will have been such a document, and I think that probably is the Human Rights Memorandum. And I don't think we've got it in the authorities, have we? I'm sure we can provide it if the court would find that helpful.
Yes, Ms. Giovanetti,
Yes.
we want a copy of that supplied within 7 days. Is that fair?
Absolutely, we'll do our best to supply it tomorrow.
Do our best? Supply it.
Yes. No, sorry, I said we'll do our best to supply it tomorrow, but definitely
see.
within 7 days. Sorry, I'm
Thank you.
muttering.
I'll make a note of that. And if anybody wants to make submissions about it, brief submissions in writing within a further 7 days. Thank you.
Whilst we paused, what she was seeking originally was indefinite leave to remain. What
Yes.
she's got is 30 months leave.
Yes.
Is it academic, therefore?
It is academic because if her appeal had succeeded, she would only have been entitled to 30 months because that's what grant that you get if a human rights appeal succeeds on Article 8 grounds. It will usually be followed by a further grant of leave and eventually into indefinite leave to remain, but the initial grant's for 30 months. Then the second determination's at tab 4. And that's the presidential panel determination.
Yes.
The relevant section begins at MS page number 389 under the 4th issue. And continues effectively until the conclusion overleaf at 391. Again, could I rely on the whole of paragraphs 28 to 33 inclusive?
We'll read that in our own time.
Thank you. But could I highlight the fact that at paragraph 30, the upper tribunal set out the paragraph of AM Malawi that I just took you to, that's 32, and went on to say judges and practitioners should be constantly alert to this clear and concise formulation of the principle of precariousness. And then at paragraph 32 to 33, they give precarious, it's just its ordinary meaning.
And you said this is a presidential decision, but it doesn't have any more status because of that, does it? And
Well, no, I just think last time I was in this court, when a series of presidential decisions were being relied upon against me, it was continuing to do presidential decisions, and the court seemed to be impressed by that. I suppose they have guidance value.
No, but I mean, the formal position is surely like the High Court, that they would pay respect and you would normally treat a decision.
Yes. I'm sorry, there was a...
But there is in this appeal, as I recall, provision for starred decisions or decisions which are given special status under the rules, and indeed under the practice directions.
I would have to check, and again, we'll come back to if this is wrong, but I haven't seen a starred determination for many years, and I think it's now reported determinations. Mr. Southey's agreeing with me, and these are reported determinations. So the upper tribunal will decide, the president will decide when a determination is of sufficient significance.
But it's a formal thing. I mean, Mr. Southey will know.
Yeah.
Under the rule, I mean, I remember this because I had to sign off practice directions when I was senior president. And certainly in those days, there was a practice direction which dealt with cases which were given special status and were expected to be followed.
Yes.
Is that right?
Yes, and sorry, what I was saying was that they're no longer called starred determinations, they're now reported determinations, and these are reported
Well, then
determinations.
why would not, if the first one was a reported determination, why was it not followed as a matter of course?
I'm sorry, I didn't quite hear that. If
the first one was a reported determination in the technical sense of
Yes.
being one picked out under the practice direction, why was it not followed as a matter of course? Why is the issue open for reconsideration second time round?
Well, I think there may have been other issues in this case, but certainly the tribunal president took the opportunity to reinforce paragraph 32.
I'm trying quickly to remind myself what Lord Justice Sales said about these two decisions, these two, as it were, bright line decisions on precariousness in our case.
Yes.
I can't immediately see him addressing
No, I don't think
the bright line.
I don't think AM was referred to by him. Dealer was.
I know, but I think in another context, Ms. Giovanetti.
That may be right.
36.
Thank you.
I don't think he bites on the broad proposition that found favour in the upper tribunal.
No.
Yes.
Which was the next one I was about to go on to.
Yes.
Yeah. Where I think we've just got as far as 32, and then at 33, the Tribunal says, giving effect to the principles and approach outlined above, I conclude unhesitatingly that in enacting these statutory provisions, it was the intention of the legislature that a person who's granted limited leave to enter and remain in the United Kingdom as a student is possessed of an immigration status which is precarious. Such status regulates the life, arrangements and affairs of the person concerned for a measured period of time and with no assurance of continuation or extension. It doesn't extend beyond the short or medium term. Its effect is to convey to the beneficiary from the outset an unequivocal message or admonition that permission to reside in the United Kingdom for the permitted purpose and complying with all of the stipulated conditions will expire on a specified date or sooner in certain eventualities.
Yes.
And whilst it's probably of limited assistance, I remember that at the last hearing which I appeared before this court, Lord Kerr, I think, having said we have to be cautious about looking at dictionaries, then said he couldn't resist the temptation over lunch and came back with the OED. So we've provided it on this occasion in case you're assisted by it.
Yes. Which
And I think
bit do you want us to focus on, Ms. Giovanetti?
it seemed to me that the bits that were most helpful or most apposite were at 1, especially of a right, tenancy, etc., held or enjoyed by the favour of and at the pleasure of another person, vulnerable to the will or decision of others. And then at 3, at B, uncertain, insecure, unstable. And that's all, broadly speaking, the approach that the upper tribunal has adopted.
Yes.
So against that background, could I turn to the approach Strasbourg's adopted, because it's my submission that nothing in that domestic approach, which we would commend to this court, is inconsistent or incompatible with the Strasbourg approach. And we were looking at Jeunesse a moment ago, and it's plainly particularly authoritative, being a recent decision of the Grand Chamber. And I know the court looked at it in some detail when we were, when the court was hearing the cases of Ali and Agiarco and MM. We've just looked at the introduction to the court's assessment at MS 547, paragraph 100. I wonder if I could go past that a little bit. And before I look at the court's reasoning, could I make one point, which again may be an obvious one, but it's an important one. The Strasbourg Court is laying down principles which need to be applied by numerous signatory states. And it starts off by reciting, as we just saw in paragraph 100, that immigration control is primarily a matter for the signatory state. And in all of these various cases, before the court gets to its own assessment, it sets out the domestic law provisions. And of course, they're very, very different. So it's not surprising that the court speaks in broad terms, that it doesn't define precisely what it means by settled, or precisely what it means by precarious. It's not going to speak in terms of indefinite leave to remain. The case we looked at this morning with Mr. Southey about Russia seemed to suggest that in Russia, in family cases, somebody gets renewable one-year residence permits until they get Russian citizenship. Very different from our own system. So it's not going to be helpful for the Strasbourg court to lay down specific criteria which might simply not work by reference to the domestic immigration law regime of a particular state. But it's used language which, in my respectful submission, makes pretty clear what the two broad categories are. And if you read the whole of paragraphs 100 to 108 of Jeunesse, in my respectful submission, it becomes tolerably clear that settled means settled for the long term, and residence means ongoing long-term residence. So at paragraph 102, yes, it records that Mrs. Jeunesse never held a residence permit, but then it goes on to say, her stay in the Netherlands therefore cannot be equated with the lawful stay where the authorities have granted an alien permission to settle in their country. That doesn't, on its natural meaning, include where the authorities have granted an alien permission to come for a year or two to study or to come to work for a fixed period. They're talking about settlement. It becomes increasingly clear as you read on. So, at paragraph 103, they talk about toleration while awaiting a decision on an application for a residence permit. If you look at the Dutch cases, for example, you see that what somebody gets under that system is initially a residence visa, and then they can enter on that while they're awaiting the grant of a residence permit. So you don't need a residence permit to be present lawfully. It's a very different immigration system. But what they say is, if a state tolerates somebody's presence while they're waiting for a decision or a fresh application for a residence permit, such a contracting state enables the alien to take part in the host country's society, to form relationships, and create a family there. However, this doesn't automatically entail that the authorities of the contracting state are, as a result, under an obligation pursuant to Article 8 of the Convention to allow him or her to settle in their country. Again, they're talking about settlement there as long-term residents continue, build their family life, put down their roots there. In a similar vein, then it deals with fait accompli and says, the last sentence of 103, the court has previously held that in general, persons in that situation have no entitlement to expect that a right of residence will be conferred upon them. Again, they are plainly talking about a right of residence in the long term. It becomes, in my respectful submission, even clearer when we get to paragraph 104. The instant case may be distinguished.
Well, we read this morning.
We did, but we didn't read on quite as far as I'd like you to, because we read the first sentence, which is instant case may be distinguished from cases concerning settled migrants, as this notion has been used in the court's case law, namely persons who've already been granted formally a right of residence in a host country. The importance of the second sentence is that it demonstrates that they're talking about an ongoing right of residence, because what they say is a subsequent withdrawal of that right, for instance, because the person concerned has been convicted of a criminal offence, will constitute an interference. They're talking about the Maslov-Una case as somebody who's got an ongoing long-term residence right which is withdrawn because of their conduct. And they contrast the approach to settled migrants, that category, at 105, with those of people who are seeking admission. Now, I know this court has said, well, in both contexts, you've got to strike a fair balance. I'm not putting enormous weight on a difference in approach to negative and positive obligations in terms of analysis, but in terms of substance, the importance is that we see the court goes on at 108 to make it plain that it's very much harder for a non-settled migrant to succeed under Article 8. So when family life was created at a time where the persons involved were aware that the immigration status of one of them was such that the persistence of that family life within the host state would from the outset be precarious. It's not the family life that's precarious, it's whether you can enjoy that family life there in that country as opposed to somewhere else. It's the court's well-established case law that where this is the case, it's likely to be only in exceptional circumstances that the removal of the non-national family member will constitute a violation of Article 8. So broadly speaking, I say those are the two broad general categories that Strasbourg's identified. And this appellant, her right to be in the United Kingdom, as you'll have seen from the Statement of Facts and Issues, ended in 2010, even if one counts the period when it was extended pending the determination of her first appeal. So by the time the matter came before the first-tier tribunal in 2015, she hadn't been lawfully present in the United Kingdom for 5 years. She was somebody who was asking to be given a right to reside here. She wasn't somebody who was complaining about a withdrawal or termination of an ongoing and continuing right. Before I leave Jeunesse, could I just draw attention to one other paragraph, which is not central to the analysis of precariousness, but I think it may be important just insofar as it adds context to paragraph 116, which Mr. Southey relied upon this morning, about the significance of the fact that she had been there for a long time. 115 is critically important to the reasoning, and as with so many Article 8 cases, you can't just take one fact out and say, you see, that's how you approach these sorts of cases, because the court starts 115 by saying that it first and foremost takes into consideration the fact that all members of the applicant's family, with the exception of herself, are Netherlands nationals. Appellant's spouse and 3 children have a right to enjoy their family life with each other in the Netherlands. And then, very unusually, the court further notes that the applicant held Netherlands nationality herself at birth. She subsequently lost her nationality when Suriname became independent. Then the last sentence, consequently, her position cannot be simply considered to be on a par with that of other potential immigrants who've never held Netherlands nationality. It was a very unusual case. And when one reads it all, it seems unsurprising that on the facts, the Strasbourg court held that this was sufficiently exceptional to require the grant of a residence permit. I'd like to come back to the question you asked me about whether her status continues to be precarious now with a grant of 30 months. Maybe I could do that at the end, because before I do, I think maybe I should turn to another point that my Lord raised this morning, why a difference between family life and private life in the Act. The tribunal, the upper tribunal, in these cases has, for a long time, even prior to the Act, adopted a slightly different approach to family and private life. And I think it's probably best explained in the decision in Nassim, which you have at tab 35 of the authorities.
That's bundle 3.
Volume 3, I'm sorry.
Very well.
Page?
MS page 1045. In fact, the decision starts at 1041.
Yes.
And there's an interesting section that starts, in fact, at 1044, under the heading Article 8 in the context of work and studies, and maybe I should draw attention to all of that section, but what I particularly wanted to draw your attention to at the moment is paragraphs 14 to 17.
Right, well, this is an answer, perhaps, to a question of mine that isn't directly relevant, but just posed out of interest. And so, would you let us read it to ourselves in our own time?
Absolutely,
Very well.
yes. Like the case of AM, I think probably the nub of it is at paragraph 17, the last nub, which is that effectively that a lot of private life can generally be replicated. So you have a network of friends, of engagement with the wider world. You'll probably have left that behind somewhere if you came to study in the United Kingdom, and equally if you go back you can re-establish it, whereas if you're separated from members of your family, that's very different. And so I think that probably underpins it.
The evidence was that the mixture of affairs between the appellant and Miss Charles, the combination in their daily living and their arrangements, the arrangements for Miss Charles to get to work, the arrangements for her to go to hospital were so intertwined that, forgive me, I did wonder why. That wasn't a family situation.
Yes, I was conscious of that this morning when my Lord asked the question. I think if one goes back to the first-tier tribunal determination, the appellant seemed to be at pains to emphasise that it wasn't just out of friendship that she was helping Miss Charles. She also felt it was part of her religious obligations. They were members of the same church group. The first-tier tribunal judge made reference to the carers concession, and of course there is a policy about carers. And I know when I was first instructed in this case, I sat down with Mr. Bias and we went through it very carefully to try and make sure that she didn't qualify under that, but she didn't. So it's not that there isn't provision made under domestic law for carers, but it didn't meet the criteria here.
Very well, thank you.
She could have advanced it on the basis of family life, but it never was.
Indeed.
And I mentioned this morning that the Strasbourg cases on precariousness and Article 8 appear all to be about family life. In terms of a suggestion that the domestic approach is incompatible with Strasbourg, it's right to say that nobody has identified any case amongst the voluminous learning in this area where the Strasbourg court has held that it's a breach of Article 8 in its private life aspect, not to grant further leave to somebody who was given permission to be in a state for a specific purpose. None of the precariousness cases or the temporary cases demonstrate anything suggesting that. It would be a big leap beyond where Strasbourg's gone. It takes, as you've seen, quite a restrictive approach to family life. It's part of the ordinary incidents of moving around the world, as people do these days, that you build bonds. Nobody's suggesting that people should not build ties and develop a social life and strong friendships. But to say that a state is thereby obliged to allow the person to remain permanently is a big step, and it certainly isn't something that's recognised as being part of Article 8 and its obligations by Strasbourg. But I just briefly speak to Mr. Bias, and I think that may conclude my submissions on precariousness. Nothing else. So, my Lord, in terms of, if I revert back to your question about the 30-month leave that she's been granted, I mean, our primary case would be that, yes, that would be precarious because it's dependent upon a further grant of leave and one doesn't know what the policy will be.
In 5 minutes you were talking about, well, long-term status wouldn't be precarious. And I thought to myself, 30 months, long-term, 30 months? I thought.
No, by long term, I mean where you will not require further grants of leave. I'm
Yes, I see.
adopting really the approach adopted by the upper tribunal, where your continued residence will not be dependent on the grant of further periods of
Very well.
leave in circumstances where the rules may change in the meantime.
Thank you.
Mr. Vanetti, dealing with that point before you move on, in the Court of Appeal, Lord Justice says, paragraph 44, interested that although the AM Malawi was not cited, that Dilo was.
Yes.
And yet he doesn't refer to the apparently very firm view expressed by the President of the Tribunal in both of those cases.
No. I mean, he didn't need to go any further for the purposes of this case. And, sorry, I'm just trying to fish up the decision. I think he started off by saying he reserved his position, but it was pretty clear that he was not enthusiastic about our case at its highest, which is that it needs to be indefinite leave to remain. My respectful submission, whilst it might lead to hard cases, I think that's dealt with by the Court of Appeal's recognition that where you have a particularly compelling case, then it's appropriate to give more than little weight to private life. So, for example, if during this appellant's next 30 months with leave, having met the 20 years, there was a sudden change to the immigration laws, it's very difficult to conceive of, and the Secretary of State decided she was going to remove her, I think the first-tier tribunal might consider she had a particularly compelling case for reliance upon Article 8. Having satisfied the rules, having met her 20 years, having been granted an initial leave, and not having done anything herself.
Well, is this a neat way into Mr. Southey's Route 2?
Yeah. Well, not sure there's much between us on Route 2 because the Court of Appeal accepted, and we don't seek to suggest that it was wrong, that in an appropriate case, one could grant more than little weight to private life, but it would have to be particularly compelling when you look at the sort of exceptional circumstances that Strasbourg requires in a precariousness case. And so I'm not going to try and be prescriptive about it because obviously you cannot define in advance categories that will be particularly compelling. Well, it may very often be an unusual combination of circumstances. And I can see why the first-tier tribunal judge was sympathetic to this particular appellant.
Well, quite. I mean, if asked the question, the first-tier tribunal judge might well have said compelling circumstances. He did rather think that he was required, having found that her status was precarious, to reject the Article 8 claim, didn't he?
Yes, he did.
And you accept that was an error?
I accept it was an error. The Court of Appeal accepted it was an error, but they said it wasn't a material one. The upper tribunal had also concluded that there was no material error. The Court of Appeal, I think, just trying to find the page.
I don't recall the upper tribunal judge picking up on this particular point, Ms. Giovanetti, and saying, well, the first-tier tribunal judge wrongly thought he was really boxed in following his conclusions. But it doesn't matter.
No.
I know the Court of Appeal said that.
Yes, the Court of Appeal
but I
did
think
say
you just said the upper tribunal also said that.
Well, if you look at paragraph 23 of the upper tribunal determination, it's not precisely the same point, but it's very close to it. It's MS page 168, paragraph 39 of the appendix section of the core bundle.
Yes.
Sorry, what's the MS page?
MS 168, paragraph 23.
I see. Well, you say that that is a recognition of the fact that the first-tier tribunal judge had wriggle room, but it wouldn't have made any difference.
Wouldn't have made any difference, the upper tribunal said. And really they're making the point that in this particular respect, the Act wasn't making the approach harsher than it had been previously. And the decision of Tier 1, which is cited there, you've got it in the authorities bundles, but the key paragraph, and this may be more convenient, is part of the reasoning I just asked you to read in the Nassim case at tab 35, starts at MS 1041, and it's at MS 1046. I wonder if it would just be helpful to turn it up, because it's quite useful to see the pre-Act approach.
Paragraph 15, did you say?
Paragraph 15, my lord, yes, at the top of the page. So they refer to and in particular the head note, when determining the issue of proportionality, it will always be important to evaluate the extent of the individual's social ties and relationships in the UK. However, a student here on a temporary basis has no expectation of a right to remain in order to further these ties and relationships if the criteria of the points-based system are not met. Also, the character of an individual's private life relied upon is ordinarily by its very nature of a type which can be formed elsewhere, albeit through different social ties, after the individual is removed from the UK. So overall, my respectful submission, 117B5, interpreted as the upper tribunal has been interpreting it from the outset, but with the flexibility imported into it by the Court of Appeal to depart where you have a particularly compelling case and Article 8 demands it, does no violence to the language. It's consistent with the approach adopted by the tribunal throughout, and most importantly, it's compatible with the case law of Strasbourg, including the Grand Chamber, as to the weight to be given to Article 8 in cases of persons who are not settled migrants.
And the exception for compelling circumstances comes from which provision in the Act?
I go back to the Court of Appeal's judgment. Oh, sorry. It's 44, isn't it? Oh, sorry.
It's
I've
the
ended
have
up with the wrong
regard
copy
point,
of this.
isn't it, Miss Giovanetti?
Sorry, my lord?
It's the have regard point.
Yes, it is exactly the have regard point. I was just trying to find a specific provision, but I've ended up with Mr. Bias's bundle rather than mine, which
Anyway,
is...
that's where both you and Mr. Southey say one can find it.
Yeah.
It's quite interesting also that the phrase is little weight. It doesn't say no weight.
No, it doesn't say no weight.
And little
no.
weight is a movable feast.
Yes, yes, yeah. No, I would entirely accept that. It shouldn't be read as no weight.
Can I just pick up a point I raised earlier about the practice direction? Unless things have changed, the practice direction, which I signed in 2010 was re-signed by Lord Justice Sullivan in 2014, says, paragraph 12.1, reported determinations of the tribunal which are starred shall be treated by the tribunal as authoritative in respect to the matter to which the starring relates, unless inconsistent with other authority, which is binding. Now, I'd be interested to know whether that still applies, and if it does, whether it's ever used.
Yes.
Because I am concerned, I think we might want to say something about how these sort of cases can get determinative decisions quicker, because it occurred in the other case we had where you get it floats around in the upper tribunal for a bit, it then floats around the Court of Appeal, and eventually gets up to us 4 years later.
Yeah.
And there is now a leapfrog provision, I think, but
Yes.
I mean, I would like to know whether there's some reason why one can't use a starred decision at the tribunal level.
Yeah, I suspect that Mr. Southey and I are capable of getting together and providing a short agreed note on this. I think that's a practice direction for tribunals generally, isn't it?
No, it's the one, because there is a special provision in the Act and the rules. which allows that. I mean, there are other provisions in other categories of tribunal.
Yeah.
I think, but I mean, I've not been involved for a few years.
I know there has been a practice direction relating to reported determinations, but I'm sure we can fish it out and provide an agreed note as well, if that helps. Oh, yeah.
Do you happen to know whether any decisions have been attempted to leapfrog any decisions from the upper tribunal?
I'm not aware of any, no. No. Hugh, are you?
Is it
No.
something which would be favoured as a way of getting these cases up? I mean, it does seem very unfortunate. Here we are dealing with a point of general importance in relation to an act passed 4 years ago, and it's taken 4 years for us to considering it. Anyway, I throw that out because you may want to say something about it.
So I think that is all I wanted to say about precariousness. Sections 117B2 and 117B3, relevance of the ability to speak English and financial independence. There's not very much I want to add to our case about that. Safe to say that the best explanation that I've found is, again, in the upper tribunal decision of AM in tab 2 of the authorities. MS 299. Paragraph 14, at least according to my note, which I hope is accurate.
Sorry, we're going to Authorities Volume 2?
I'm sorry, I'm probably
My
not
fault.
standing quite in the right place. It's Volume 1 of the Authorities Bundle, tab
Thank
2.
Thank you.
It's AM again, AM Malawi,
Yes.
which starts at MS 290
Yes.
and at MS 299, paragraph 14, which we haven't looked at yet, and so we started at 20 on the facing page. Paragraphs 14 and 15.
So you say that financial independence and English language fluency are not positives in themselves.
No.
Of course, they may come in indirectly. Somebody who's financially independent, and perhaps in particular, somebody who speaks English fluently, may be more able to establish a significant private life here than others.
Yes, so they might feed into other
Feed in.
factors, but to
Yes.
suggest that there's a public interest in granting leave to enter or remain in the UK to people who speak English or are financially independent would effectively mean there's a public interest to grant leave to enter and remain to vast swathes of the world's population. It's just plainly not what was intended, and this plainly is. But I absolutely accept that they may well feed in indirectly in other ways.
Yes? Well, there's not much more to be said about that, is there, Miss
I don't think
Giovanetti?
there is, my lord, no. Just on that point also, it's the same points effectively I looked at in Nassim, which is at tab 35 of the authorities, which I think is volume 3. And just for your notes, that's paragraphs 25, 27. And I think that's all I wanted to say about those 2 points in terms of the general approach and interpretation. In terms of financial independence, as I hope we've made clear in our written case, following the approach that was adopted by the Secretary of State after this court's decision in Lebanon, the onus of course remains on an individual to satisfy the Secretary of State or, in an appeal, the tribunal as to the reliable, enduring nature of the financial support they're in receipt of. This appellant didn't do that, but she didn't do that effectively because the tribunal was simply saying you're not financially independent, as in you're not self-supporting, you're reliant on funds from others. So in the ordinary course, it seems to us that if the error was a material one, what the court would do is remit. I say it's not material for two reasons. The first is a pretty obvious one, that the appellant now has the leave that she was seeking in her appeal to the tribunal. So this is really entirely academic. But in any event, if we are right on the meaning of precariousness and little weight fell to be given to her private life, then given it's a neutral factor at best, it's difficult to see how it could have made any difference to the outcome.
I'm not sure the recent grant of permission renders this point not material. I thought you were going to say, even if it was material, you still got a discretion about disposal. And in the light of the recent grant, you wouldn't exercise your discretion to remit.
Yes, I am sorry. I think that is absolutely the right analysis, and I should have put it in two different ways. So yes, there would be no point in remittal because of the recent grant. My second point remains, I think, that it's not material if we are right.
I think that does remain as a materiality
It does.
point.
I'm very grateful, my Lord. Thank you.
Am I right in thinking that what is the Department's position on what's meant by financial independence was affected by our decision in Lebanon?
Yes, it was.
I assume, which came after
Yes.
Court of Appeal's decision
Yes.
in this case. So that
Yes.
may
Yes.
explain why there was a change.
Yes.
Thank you.
That's absolutely right. You may remember at the end of Lebanon, the Secretary of State said that, I think it was she at the time, that she would go off and look at the approach to financial independence, and it has been revised since then too. And they're quite detailed provisions,
Yes.
but yes. So, finally, the approach on appeal and re-B.
Yes.
I am not going to take very much time over this at all. I'm not even going to go to re-B. We looked at it in great detail this morning. The court is obviously very familiar with what it says. But I say that on a correct interpretation of the decision and the reasoning of the majority in re-B, what is absolutely plain and would be in any event so contrary to principle is that what the court doesn't do is start off by conducting its own proportionality assessment. Because we'd be approaching this case very differently if it did. But it doesn't start by conducting its own proportionality assessment and then say, now, let's see what the first instance judicial decision maker did. If it's not the same outcome as we have found, then it's legally erroneous. That's not what the court meant by, is it wrong or is it not wrong? You're looking at something quite different. So what the court was very plain about in re-B is that on appeal from a judicial decision maker, so we're not looking at sort of the misbehaving scenario when the court's conducting a first instance appeal from an administrative decision maker, but on an appeal from a judicial decision maker, what the court is doing is conducting a reviewing function.
So you've told us what we shouldn't do. What should we do, Ms. Giovanetti? What test should we apply?
You should look for an error of principle or a decision which is wrong in the sense of being impermissible. I'm sorry, I'm not telling you what you shouldn't do and should do. I'm giving you our submissions on
Yes, of
Rhuppiah and the
course.
case law, obviously. But yes, as long as wrong is read as impermissible, rather than not the same outcome as we have reached conducting the proportionality exercise for ourselves, I think it all works.
Not within the band of permissible decisions.
Yes.
Is that what you mean?
Yes. Yes. Which is not quite, I mean, it's not a Wednesbury approach. I'm not suggesting it is, but that grey area in the middle that I think my Lord Hughes was talking about it this morning, because you can't really approach it on the basis that wrong means a different conclusion to ours, unless you start off by conducting the whole exercise yourselves. And that, in my respectful submission, is not what the role of this court, or ordinarily the Court of Appeal, should be on an appeal in point of law. Unless Mr. Bias had on my instructing list, could I briefly turn my back for a moment just to see if there's any other
please.
submission I should be making that I've missed? No, nothing to add at all, other than we've got a copy here of the letter granting leave to remain, and I don't know if you would find that of any assistance to have with your papers to this appellant.
Well, do you say it would assist us, Ms. Giovanetti?
Well, we've told you about the grant. I don't think there's any dispute about it, but just for completeness, in case in the course of your consideration you thought it would help to refer to it, it certainly wouldn't do any harm.
Well,
for
you
to
know
have it
whether
available.
it would help. You're not convinced it would help.
I'm not
So
convinced it would help.
unless Mr. Southey says it would help, we won't look at it.
No.
But we found on our desks when we came in 3 documents that I don't think have been referred to in the submissions.
What are
The
those?
Patel case, Immigration Act 1971, Section 21, and Statement of Intent Family Migration. Did they come from you?
They didn't come from us. They came from the appellant. They were given to us this morning, I think on the basis that they might need to be referred to. They weren't referred to, so I'm not proposing to go to them at all. Patel's a near-miss case. I mean, the court will be familiar with it. It's, and I have no objection to them being with your papers.
I just wanted to understand how they came before us, and oddly, in a sense, they are before us, but they haven't been used.
No, well, they're not
Very well.
ours, but
Right, very well.
thank you,
Ms. Giovanetti, thank you. Mr. Bias, are you going to follow?
Lord, thank you, but no.
Very well. Mr. Southey.
My Lords and my Lady, I probably should apologise for putting things before you and not referring to them.
Don't worry.
It obviously, because of time, Patel, obviously, as my learned friend said, is the near-miss case. Just so the court's aware of it, we discovered overnight, I think, the family policy, which sort of is it was part of the background, essentially, to the immigration rules that came in 2012, trying to codify Article 8. And,
Well, can we put these 3 documents to one side?
yes, I'm quite happy for them to go.
Thank you.
Thank you.
Yes.
Can I turn to my learned friend's submissions? My learned friend started by drawing attention to the margin of appreciation. And of course, I accept that the United Kingdom enjoys a margin of appreciation. The United Kingdom is entitled to set its own immigration policy. But as is also quite clear, there are limits to how far it can go. And essentially our point is, and remains, that the policy of the United Kingdom in this sort of context, where someone only has a right to remain on the basis of Article 8, has been pre the 2014 Act, essentially to adopt a firm approach, to use language that everyone will be familiar with, to immigration control, to essentially go what might be described as at least close to the edges of the margin of appreciation. The rules, for example, the 2012 rules that I've just referred to, were clearly intended to take the United Kingdom close to the edge of the margin of appreciation. And our point about that is that the 2014 Act essentially doesn't change that. It is still intended to take the United Kingdom close to that margin of the edges of the margin of appreciation, not to take the United Kingdom over that margin of appreciation. That's why I started by saying this is not a piece of legislation essentially that says, for example, Parliament has decided that Article 8 is disapplied in this context. That, I happen to notice in Malone, of course, Malone and Friend submissions, is in fact reflected in the Upper Tribunal decision in this case, paragraph 23 that Malone and Friend took the court to, memory stick page 168, talks about there being nothing new in the 2014 Act. And that's why we say, as Malone and Friend says in her statement of case, the purpose of the legislation is essentially to adopt a structured approach to Article 8. That's the language she uses at paragraph 9. But that means that the ultimate question still must be whether there is in fact compliance with Article 8. And that's important because one striking difference between my learned friend submissions and my submission, that in my submission is of some importance, is I think at several times made the point, standing back, does this seem to be a case where the balance has been fairly struck? No, it's not on our submission. My learned friend was at best tentative in trying to defend the balance on the facts of this case. The second point is my learned friend then said, essentially, of course, the United Kingdom does adopt rules intended to ensure or intended to respect people's private life. And she referred to Rule 276 ADE. It's volume 2, tab 17, memory stick page 662. And I'm not going to take the court to it, but the court will remember that's the provision that allows, for example, for people who've had 20 years unlawful residence to obtain further leave, the provision that ultimately benefited the appellant. The key point about that is, in my submission, and nothing my learned friend submits in my submission undermines that, is that that is a recognition, ultimately, that while people are present here, whatever their status, they will not put their lives on hold, and they will ultimately develop ties that may make it very difficult to justify removing the individual. That rule has different rules for children. It allows children to benefit, for example, after they've been present in the United Kingdom for a shorter period. So it is a flexible rule that it tries to strike a balance. But the basic point is it reflects that the fact that people build private life while present, and that's something that was also recognised in Jeunesse. I won't take the court to it. It was paragraph 116, the paragraph I drew attention to in opening, which made the point that even while tolerated, and this is not the position of this appellant, people do build private life. And that's the context in my submission in which the legislation should be viewed, because the legislation in my submission does not seek to disapply effectively the approach adopted in Jeunesse, which was ultimately looking at whether the balance was correctly struck effectively by the domestic authorities. Now, my learned friend then turned to the legislation and said, which is not a controversial point, that precarious is not the same as unlawful. We accept that. We've never disputed that. But, of course, as my learned friend also accepts, there is what in practice is quite a significant group of people who aren't unlawfully present, but also don't have time-limited leave. The people on temporary admission, the people who are waiting a decision, many of those will be asylum seekers. Many of those will be people who are present for a significant period of time, given the lengths of time that asylum decisions take. But the critical point is, in our submission, their position is quite clearly that they are in a situation where they are tolerated, to use the language of Jeunesse, because they're awaiting a decision. Jeunesse uses the language of tolerate in relation to people who are awaiting a decision. And if one looks at the Warren article, I've given the court reference to it before, and I'll give it again. I won't take the court to it. It's volume 6,
We've got the reference.
tab 80. There are a category of people within that who are lawfully present but have far less secure status than this appellant. Now, the upper tribunal determinations, I touched on those before, but the basic problem with those is that they ignore previous authority. They expressly say they ignore previous authority. Now, if one thinks about this, steps back from the points we've already made, that precarious seems to be a word rather, that's not defined in the legislation, but is found in Strasbourg, which in our submission is an indication that it's meant to reflect the same concept. But if one steps back from that for a moment and thinks about perhaps this at a more fundamental level, the precarious cases are essentially Strasbourg saying there is a category of cases where the state's interests in immigration control are such that you should only succeed in exceptional circumstances. Now, if the United Kingdom adopts an approach to precariousness that is broader than Strasbourg and says there's a broader category of cases that will only succeed in exceptional circumstances, that means the United Kingdom is going to be in breach of Article 8. So it can't, in my submission, adopt a broader approach unless, and the only way it could do that would be by allowing effectively greater flexibility and disapplying the limited weight approach in those cases where Strasbourg would essentially find a violation of Article 8. You can't, in my submission, as I say, adopt a broader approach to precariousness if one then adopts the same approach as Strasbourg of saying, in these cases, you will only succeed in exceptional circumstances without there being a risk, essentially, of a violation of Article 8. And that is clearly not what the legislation is intended to achieve, and nobody argues that. And that's why, in my submission, one ultimately has to turn to the Strasbourg authorities. Now, what my learned friend ultimately sought to derive from the upper tribunal was essentially, or what my learned friend sought ultimately to rely upon, was the finding that one had a precarious status if one required a further grant of leave to extend one's stay. Now, that, in my submission, in any event, is not the right way of looking at this. The reality is, because of the focus of the Strasbourg case law, which is essentially what was your status when your private life or family life developed, is to look at the fact that when the private life developed, one was entitled to remain, one had a right to remain, one wasn't in a precarious situation, status couldn't be brought to an end at a whim by taking a decision, for example, or by taking a decision to remove. One had a period which one was entitled to remain in the United Kingdom. And that's why we would submit limited leave is not necessarily precarious. And the difficulty my learned friend has, of course, is illustrated. The difficulty my learned friend has in saying limited leave is always precarious is illustrated by her answer essentially to the question, is 30 months precarious? And in our submission, the position the appellant is now in is plainly not precarious. She's been granted leave in recognition of the fact that she has been resident for a considerable period, a period that means it is difficult to remove her. True it is that if she were, for example, to suddenly develop or demonstrate bad character, it wouldn't be extended. True it is that if she were suddenly to leave the United Kingdom and not be present for a significant period and then seek to renew, it might not be extended. But the reality is it's been recognised that providing her situation essentially remains unchanged, she ought to remain in be able to remain in the United Kingdom. And that, in our submission, is far from precarious. It would mean, if one was to conduct a fresh proportionality balance, it would be difficult to justify removing her. Can I also say, finally, in relation to domestic authorities, noting, by the way, in passing, I think that Dealer, in many respects, adds nothing. It is just essentially the same approach of adopting a domestic interpretation. Of course, the Court of Appeal didn't ultimately adopt the approach of the upper tribunal. The Court of Appeal recognised that there needed to be greater flexibility, and or there may need to be greater flexibility, and paragraph 44 of the judgment in particular questioned whether limited leave was always precarious.
But as we pointed out, the Court of Appeal didn't really address the bright line rule that had been endorsed in Dealer.
It didn't expressly address, it was clearly aware of Dealer, and I actually looked up to make sure that it was aware of both cases, and certainly they were both referred to in skeleton arguments, so it was aware of both cases. So it was aware of them. It ultimately decided it was going to decide the case, I accept, effectively on the facts, without deciding for certain whether effectively the Secretary of State was right to say limited leave is always precarious. But it put a question mark at the very least over that approach.
Yes.
And as I say, our basic point is, if you start from the position that ultimately Strasbourg, as Jeunesse demonstrates, is concerned with balance, that means one has to take account of the circumstances of the case. And the reality is, the sort of situation that there was present here, where someone was present for a long period of time, had understandably built up a private life, is very different from example for the person who's been here unlawfully, has never had an expectation of being able to remain.
Can I just explore with you that you and Miss Giovanetti seem to be going to the same place by different routes. And I'm wondering why you're wedded to your particular route. That is to say, if precarious, then you can still get to the same place by virtue of there being reasons for weight being given to that private life.
I think I did say at one stage, and if I didn't, it's because I didn't get to that point in my speaking note, that in one sense I accept it doesn't matter which route one gets to.
But you are arguing very strongly for the it is not precarious route, and I'm wondering why.
Well, in part, to be frank, because that's where there's greater authority. In terms of just division of time, it's where I'm in one sense, I've got more material to cover. It's
not because there's some value judgment that exists between the merits of the two routes.
No, it's not. It's not, because ultimately, my basic point, as I've said all along, is that the role of a court is ultimately to strike the balance. And whether one gets to that, and that's quite clear from all the Strasbourg case law, and whether one gets to that by saying, essentially, one narrows precariousness so that in the vast majority of cases, maybe not the vast majority, but a large number of cases, one doesn't need to worry about limited leave, or whether one gets to it by saying have regard essentially means that in appropriate cases one can give more than limited weight, doesn't really matter in one sense. I completely accept that. Because ultimately, my basic point is the court has to, in appropriate cases, strike a balance that's appropriate on the facts. You can do that through one of two routes. It's just, as I say, in some senses, there's more material to cover in relation to the first of the routes. Can I then do, my learned friend, perhaps unsurprisingly, because we both, I think, accept that Jeunesse is key authority, argues essentially that what Jeunesse demonstrates is that settled means essentially residence, and residence means effectively a status that gives one a long-term right, was the language she used, I think. She referred to long-term.
She meant indefinite.
Yes, she meant indefinite.
She more or less said
yes,
so.
She meant indefinite, but she started by using the word long-term. Now, my point is, as I say, firstly, settlement is clearly defined by residence. Residence is not defined in the Strasbourg case law, certainly as far as either party has been able to identify. It's difficult to see why residence means indefinite leave to remain. If one thinks of it in sort of common sense terms, to use an example which is not this case, I've already made this point, the tier 2 worker will probably regard their place of work as their residence. It may well be where their children are being educated. It may well be where their home is. They may have bought a home, for example. In terms of the student will expect to continue their studies, and those studies may continue for years, even though they're having to renew annually. I mean, if you effectively start a 4-year degree course, then one would generally hope that one's going to be able to finish it. Of course, one might not pass one's exams. There may be other problems, but in general, one would hope to finish it. One would say, well, one's place of residence during those 4 years was where one was studying. Now, my learned friend, in our submission, in adopting the approach she does, overlooks the more important point, which is that the two situations that are effectively contrasted with residence are firstly the person applying for admission, and secondly the person who is tolerated while their application is decided. Applying for admission is paragraph 105, and tolerated is paragraph 103. And there's an obvious difference between those cases, the applying for admission and the case of the person who's tolerated, and this case. And the difference is that in those cases, the private life is not established during a period while the person is lawfully resident. Here, the private life was established by someone who was lawfully present, had established that they could be present in the United Kingdom, and it was established without them breaching in any way immigration control. And that means the sorts of policy considerations that I drew attention to this morning, evidenced by the Nunes case, do not apply in this case. Now, my learned friend says, essentially, it was significant by the time the first-tier tribunal was considering the case that, of course, the appellant was seeking leave because her leave had come to an end. 2 points I'd make in relation to that. Firstly, I think, as my learned friend accepts, ultimately the judgments of this court, particularly Ali, give the court the reference, it's paragraph 32, makes it clear that there is very little difference between positive and negative obligations. But secondly, and more importantly, on the facts of this case, the issue is not so much what was the situation when the appellant was applying to the first-tier tribunal, what was her immigration status. The situation was the key issue was what was her immigration status when the private life developed. And that's why I started by drawing attention to the fact that her private life quite clearly started and developed, for example, with the illness, while the appellant was lawfully present. Final point my learned friend made was there's a difference of approach between private and family life. And she cited Nassim indicating that essentially private life cases are ones where often the private life relied upon can be replicated overseas. In our submission, whether or not that's factually correct doesn't change the basic approach. The basic approach still, because it's an Article 8 right in issue, is the need for balance. Now, if in reality one has a private life that can easily be established overseas, to use perhaps a trivial example, somebody says, essentially, I play cricket in the United Kingdom, all my friends are in my cricket team. Well, one might say one has a private life, but it wouldn't carry any real weight. It'd be extremely easy to outweigh. So it doesn't suggest a different approach. It just suggests that factually, in many cases, it may be difficult, as a matter of fact, to demonstrate that private life is of the sort of nature that will outweigh the state's interests. But it doesn't change the basic approach that one needs to strike a balance. And our basic, coming back to where we start, I said a moment ago, and I don't resolve from this, in one sense it doesn't matter which route one gets to, one ultimately has to get to a point where the balance can be properly struck in any case. And if we're wrong about route 1, and we have to rely on route 2, the basic problem we submit with the Court of Appeal when looking at this is the Court of Appeal says, essentially, one needs exceptional circumstances, and that was not present here. And our submission is when one stands back and looks at this case, this is a case where the private life rather could not be replicated. It was of a pretty unique nature, essentially. It was a compelling nature. The state's interest was reduced because, as I say, it was developed while the appellant was lawfully present. And all of that suggests effectively a need for a greater flexibility than was adopted by the Court of Appeal, so that the appeal should have been allowed on the facts of this case. Finally, just very briefly, dealing with two issues. Firstly, financial independence. Can I make it very clear? Our point is not that financial independence should result in grants of status or anything like that. That's never been our case. All we say is financial independence can, and the same applies to language, can be a positive factor. Now, where it's present, in many cases it will be outweighed by the public interest by other public interest factors, in particular the public interest in terms of firm immigration control. But it doesn't mean it's not a positive factor. There are a number of factors that will go into any balancing exercise. Some will be positive, some will be negative, and ultimately one needs to strike an overall balance taking account of all those factors. And all we're saying is that the language of the statute itself indicates that ability to speak English and financial independence are positive factors. They go into the balance. In many cases, even if they're a positive factor, they will be outweighed. Finally, in terms of B, I'm not going to say very much because obviously my learned friend said very little rather. Now, my learned friends, but what my learned friend did say in my submission causes actually something of a problem for the court in my submission. My learned friend said the approach of an appellate court she accepts is not to conduct a Wensbury review. That's quite clear, we would submit. It's quite clear from Lord Newburger's judgment, but to decide whether or not the tribunal whose decision is being reviewed got the decision wrong. Now, the problem with that is that raises the question of if it's not essentially deciding proportionality directly, what is wrong in those circumstances? What is the intermediate position between an unreasonable conclusion and a wrong conclusion? And in our submission, the only principled approach, which is what we set it out in writing, and we submit it's consistent with the approach of Lord Newburger to proportionality as opposed to primary facts, is to recognise that given that a disproportionate decision in breach of Article 8 is an unlawful decision, if a decision is disproportionate, given the findings of fact that were made, that should be regarded as wrong, certainly in the vast majority of cases. And as I say, we say that's not inconsistent with B, because B was primarily looking at the first stage, which was what were the primary findings of fact. And that's not really the issue in this case. Anything else, David? My lords and my lady, I think that hopefully covers everything, but unless I can assist further.
It's frightfully irritating when people change their mind, Mr. Southey, but do you mind if I change my mind and ask Miss Giovanetti for a copy of the letter?
No, I have no objection at all to the court seeing it.
Thank you very much.
But yes.
I think you've got a number of copies there, haven't you, Miss Giovanetti? Well, let's have them now.
Mr. Southey, you don't have any experience of recent use of starred cases?
I think I do, but I was going to sort of keep my powder dry so that I didn't mislead. My experience here is my immediate reaction was that I don't think in principle the practice direction has been withdrawn, but that in practice there's been a movement away from starred decisions into reported decisions, and reported decisions are more common than starred decisions were, but are perhaps given less weight. They are...
Yes, but I mean, as an advocate, do you feel able to challenge a decision? I mean, when you get the Deputy President giving a considered view on a particular thing, do you feel that's
Certainly my view is, and not that it appear that often these days before the opportunity, but certainly my experience is to adopt an approach very similar to the High Court, and the Court will remember the ex parte tal test in relation to the High Court, and that's
what I assumed.
Yes.
Good, thank you very much.
Yeah.
I mean, here we are, 4 years after this reference to precariousness came into the law.
Yes.
And we are now deciding what it means.
Yes.
And behind my Lord's question is no doubt a feeling that it should have been decided earlier. On the other hand, if we were to have an appeal directly from the upper tribunal, we'd be losing the assistance of a Court of Appeal contribution.
Can I, from a personal point of view, as a practitioner in this court, say what I think is the biggest problem with delay? And this may or may not be something that the court regards as relevant or capable to say anything about, and that's the legal aid agency. Because the legal aid agency, because partly of this court's understandable approach of saying that time only runs from a final legal aid decision, takes Supreme Court decisions, treats rather decisions on Supreme Court funding as the lowest priority in my experience. It can take years to get a decision from the legal aid agency. This actually was quite a quick funding decision. And I can't remember how long it was, but it still took its time.
Well, thank you for telling us about that.
Yeah.
I don't think there are any more questions, and so it remains for me to say only that this case was beautifully prepared by the solicitors. Excellent written cases, no doubt partly or largely generated by junior counsel. Very good, economical, clear advocacy. This is just how an appeal to the Supreme Court ought to be presented. We'll reserve our judgments.